Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. I hope everybody is doing well on this Wednesday, the 4th of February. That's right, we're 4 days into a new month. Hope everybody has some wonderful plans. The world seems to be warming up a little bit. Not a lot, but just a little bit. I am still recovering from my trip that I was away, but we're getting back into it. So I'm a little bit behind, but it's okay. We'll always catch up. We'll get there. So what are we going to talk about today? Today we are back in court for the Karen Read civil motions, right? Just to recap, Karen Read was accused of unaliving her cop boyfriend, John O'Keefe. He was a Boston police officer. He was found on the lawn of another Boston police officer at 34 Fairview in Canton, Massachusetts. Karen Read has been tried twice. The first time she was acquitted. First one was a mistrial. Second one, she was acquitted. Long story short, the family of John O'Keefe is suing her for wrongful death. She, in turn, is suing everyone. Who's everyone? The several defendants that had testified against her in trial 1 and trial number 2, as well as 3 Massachusetts State police officers, the town of Canton, and the Massachusetts State Police. Am I missing anybody? Anyways, I've gone over it. This is just a, hey, here we are. This is the road so far. So what is going on? So in a civil case, things aren't the same as they are in a criminal case. First of all, we don't always get privy information to what's going on in the civil case. But since this is a hotly contested case, we are getting a firsthand view of sort of what a civil trial is about. Civil trials take a very long time. Why is that? Well, first of all, you'll see there are about a gazillion lawyers involved. Who gets rich in all of these things? It's the lawyers, right? Secondly, everybody's filing a motion here. This person's filing a motion. This person's filing a motion. Not only that, but right now we're in the deposition phase, right? We're also at deposition and discovery. What information are they going to glean from Karen Read's trials? What information they're going to get from that? What information are they going to get from experts and other people who have testified? What about their own experts? But mainly the depositions, right? They want to hear from the House defendant witnesses, Jen McCabe, Matt McCabe, Brian Albert, Nicole Albert, all the Alberts, whoever is involved, they want to hear from, right? They want to get them in the hot seat and be able to ask them any questions. Vice versa. John O'Keefe's family wants to get Karen Read in the seat and ask her all the questions. They want to get Proctor in the seat, ask him all the questions. So what's happening? Well, as you saw, there was a lot of motions to compel. That means we want you to produce either documents or we want you to come and schedule a deposition. And some of these participants have been a little bit late to the party. For example, Sean Good. They asked him to have a motion to compel, and he didn't answer for a while. Well, finally, he did answer, and I believe there's something in reference to that in this little hearing that we're going to hear. New attorneys are being added. It's like a big civil sandwich. But most importantly, failed to remind you that the John O'Keefe's family's civil case and Karen Read's civil case against everybody are being combined for discovery purposes only. Karen Read's case against everybody has gone to federal court. John O'Keefe's family is still in regular Plymouth court. I believe it's Plymouth. And so that one remains in the state. The other one goes to federal. Also, we covered this before, but the House defendants have filed a slap motion to dismiss the case. And they do have some merit, as well as so do some of the police officers, because it is in their capacity as a police officer to investigate, et cetera, et cetera, et cetera. We went over that. So let's get to the motion hearing and see what we can learn to all of this. And I have the spinning wheel of death, so hopefully it will start up.
If you wish, Your Honor, but I can confirm that we have some very technical folks on our end that have been trying to access the documents for the same purpose of moving this case forward. And it's been difficult. And so now we're put in the position of trying to take what has been produced and get an e-vendor involved, which is going to cost more money, of course, but we're getting an e-vendor involved, just as Mr. Diller is, to try to better access these documents. And then I would just say to, from what I have been able to see with the 518 videos, they're not, as far as I can tell, categorized in any way. My operations manager has told me that we can see that there's driveways, there's Ring doorbells, there's some body cams, there's cars backing up, which I can presume is Ms. Reed's. There's some audio files that sound like they're coming from dispatch, but nothing is date and time stamped. We're having a difficulty sort of trying to read through it and discern what is relevant and what is not relevant from those videos. And then with respect to the folders that I believe Mr. Rosenberg has referenced, we're having a hard time opening those as well. They seem to be either corrupted or not in a proper archive format, to the best I understand what my technical people have told me. So I can just say, Your Honor, we are having some similar difficulties that we would love to get past with the cooperation of all parties in the court.
Okay. So I'm going to pause right there, right? Oh, we're having problems with the documents. Oh, we're having problems with the things not working. Well, welcome to the upside down of Massachusetts. So I don't know who she is. It says that her name is something Smith, something another, with Peabody and Arnold. So I'm not really sure what party she represents. I can probably go back. Anyways, long story short, this is the way discovery is, right? They're never going to label anything. Sometimes they do, sometimes they don't. They just give you a big dump of stuff and they said, good luck. So I bet you both sides are having the same issues. Now, where they're getting this information from and why it's not categorized or what have you, I'm not sure. Maybe we can get some more information from that, but that's the way it is in court cases. So nothing really new there.
What depositions, if any, have been noticed by CNC?
We have not noticed depositions for two reasons. One, there will probably be very few from us, Your Honor. But two, we want to only notice depositions that we truly intend to take and are not duplicative of other parties. So we have talked with Mr. Diller and conferred with him on the short list of folks that we would anticipate that we would like to depose. And frankly, we've also talked to counsel for Waterfall about this. And then, of course, Mr. Diller has talked to me about some of the folks at McCarthy's that he would be looking to depose. But on both sides, it's a relatively short list, Your Honor. And as soon as we get through these documents, we are in a position to proceed with that type of discovery and with depositions.
Thank you. Why don't I hear from Waterfall, please?
Thank you, Your Honor. David Hassett. Judge, we have responded to the plaintiff's discovery, interrogatory answers, and document responses. We've also propounded discovery to the plaintiff and to the individual plaintiffs identified in the suit. That discovery is outstanding by agreement. As to the documents produced, we also have not yet commenced deposition. The documents that we have gotten through the discovery to date, we've been working through and expending efforts to get to the documents, understand the documents. We've had some challenges, but we've been trying to implement some workarounds, but that is not completed yet. And we also have a discovery e-vendor that will be assisting us in the pursuit of getting our arms around all those documents. We have been in discussions with Attorney Diller and Attorney Smith about the depositions we would be taking. There are obviously some overlap with the depositions that the Read team would be taking and the O'Keefe team, but that the separate depositions of patrons or witnesses, we conferred about those. I agree it's a relatively short list, and the hope was first to review the documents before starting that process.
Attorney Hassett, do the challenges you have encountered include the inability to access the documents produced?
Not all of them, Your Honor. We have been able to access documents, but we haven't been able to access all the documents. For instance, some of the folders that were described by Mr. Rosenberg and Mr. Diller, they will open up and they'll be blank, there'll be nothing in there, or they're corrupted. I believe we've had some communication with Mr. Rosenberg's office about some access to files and our own IT support internally. So what I would say, Your Honor, based on 990,000 pages, there is a percentage that we haven't accessed properly or completely. One thing I will also add is that there is a load file that we recently received that has metadata. It appears that that will assist in terms of accessing documents or files that we've struggled with. So that's something that we intend to do next.
When did you receive that?
I think it was in the last week, Your Honor.
Okay.
Your Honor,
Thank you.
can I just note, Your Honor, I haven't heard from either of the two bars about these issues. I'm happy to work with them, just like I've been working with Mr. Diller to have these documents assist with whatever technical issue that they're having. I just haven't been aware of those yet. So if they reach out to me, I'm again happy to help with that. But I understand there is a lot of paper here, and there is a need for e-discovery vendors because primarily the plaintiffs have asked for all of these million pages of documents. So I understand why all of the parties are explaining the need to access things in order to go forward and proceed even further with discovery. But I just want to be clear, to the extent there's any technological issue, parties need to reach out to us and let us resolve those, which we will do.
But the common theme seems to be that they're all having some difficulty.
Well, I agree with you based on what I just heard, Your Honor, but I'm not aware of that until just this moment. The only party I've conferred with about these issues is Mr. Diller, and we've been talking about it for, I think we'll agree we've been talking about it for a month or more. So I'm more than happy to do that, and I don't know what the issue is from the other defendant's perspective. I know from Mr. Diller's consultant what the issue is now, which I believe we've resolved, and he's said he should be able to know that shortly. So I would suggest I'm happy to speak with anyone that needs to in the next couple days to address any technological issues that are remaining.
So Attorney Rosenberg, in November, Attorney Waters indicated that the Read team had sent out between 10 and 12 subpoenas.
That's correct.
And it appears you've resolved, at least for now, issues relative to Sergeant Good, Mr. Proctor, as well as the Norfolk County District Attorney's Office. That's 3. Who were the other parties that notices of deposition went out?
So there's only been one. There's only been one. Sorry.
Well, Attorney Waters indicated between 10 and 12. I've just addressed 3 of them, so that leaves 7 to 9. So you said there's only been those 3?
No. So the question to Attorney Waters at the last hearing was subpoenas. Those were primarily document subpoenas. The deposition subpoena and the notice of deposition, which is the only deposition that's scheduled thus far in this case, is our deposition of Michael Proctor, which we've finally locked in with everyone's availability, all parties, counsel, and Mr. Proctor and his counsel's availability. And that'll be going forward in April. We have not yet scheduled other depositions, but we from the Read side plan to do so very shortly. And as you can tell, obviously the discovery from our end is going to be primarily third-party discovery. So there will be additional depositions put on the calendar soon, as soon as we're able to coordinate schedules, which has obviously been daunting in this case.
So just so I understand, what subpoenas have been sent out?
So we've sent 2 subpoenas to Michael Proctor because there was additional information that became, we became aware of. We've sent a subpoena to the town of Canton. We sent a subpoena to the Boston Police Department. We sent a subpoena to the Massachusetts State Police, sent a subpoena to Sergeant Good, as Your Honor said. We sent a subpoena to, I don't know if I said the district attorney's office, but both us and the plaintiff sent subpoenas to the district attorney's office. We sent a subpoena to Mr. Proctor's prior attorney in connection with his appeal, just relating to this one particular issue that is relevant to the district attorney's office subpoena. There might be 1 or 2 I'm not thinking of off the top of my head, but that's the bulk of them thus far.
When did the subpoena go to the town of Canton?
The subpoena to the town of Canton went, off the top of my head, July or August of 2025, I think.
And have you received a response?
We've received documents. We are currently discussing with their counsel additional documents that we had been under the impression they didn't have, but now I believe they may actually have. So I'm in the process of
What they magically appeared, just like the video of the Sally Port. They just magically appeared. Are they in someone's file somewhere? Anyways, you can't. So, long story short, this is a status hearing, right? The judge is the keeper of the records and the keeper of the organization of everything. As you can see, there's all these attorneys here, right? So remember, the 2 cases are somewhat combined when it comes to discovery. There's also, I forgot to mention, the Waterfall Bar and C.F. McCarthy's. So remember, Karen Read and John O'Keefe started their night at C.F. McCarthy's, drinking a lot. That is where actually the glass that came from, that he was found with, came from C.F. McCarthy's, because he then took that to the Waterfall. And then the Waterfall, they went to 34 Fairview. So that's where all the parties are considered. So it's not just the bars, it's John O'Keefe's family. I think Mr. Diller. So Mr. Diller, who's up here, represents John O'Keefe's family. Mr. Rosenberg represents Karen Read. This guy is the Waterfall. This is Miss Smith. She is from Peabody and Arnold, I believe, and she represents some of the House defendants. And then I'm not sure who all of these lovely people are. But let's continue, because this is exciting. So the judge basically is just saying, okay, you sent out these subpoenas. Have people responded? And he sort of is the one who's he's pushing things along, right? That's his job, paper pusher. And what can he do to help push things along? If people aren't supplying discovery like they're supposed to, they're not going to depositions like they're supposed to, the judge can intercede.
of a 9C conference with their counsel to determine if they will produce these additional documents that they should produce from our perspective.
When did the subpoena to the Boston Police Department go out?
Roughly the same time. So the first subpoenas we sent all around the same time was the town of Canton, the Massachusetts State Police, Michael Proctor, and the Boston Police Department. Those were all July to August. And then, as I said, we followed up with a second subpoena to Mr. Proctor approximately September of 2025.
Would you agree that 8 months to resolve issues from subpoenas might be a little unreasonable?
I certainly would, Your Honor, but here's what's been happening in this case. Every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena, as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department, Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now. And it takes time to even get people on the phone. We get them on the phone. There's continued refusal to produce documents. We attempt to confer as we're required to under 9C to try and get documents without burdening the court with motions to compel. We then, in some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor.
Oh, you've got to be kidding me. Oh, you've got to be kidding me. Proctor lost his phone. Oh my gosh. You can't make this crap up. I mean, come on. Well, somebody has the information. How are they going to get it? Let's see what the judge has to say. Produce. Come on. You are being compelled to produce that information. It's downloaded somewhere, buddy.
So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for 2.5 months negotiating an agreement with the district attorney's office, which would only give us these relevant documents, despite the civil rules, would only give them to us with onerous restrictions that are unusual if never occur in civil cases like this. But we agreed to that because we need to get the documents. So I 100% agree with you.
They want them to sign the non-disclosure that only the interested parties are able to see this information and that it doesn't go out to anybody because these must be the 10,000 plus messages that were downloaded off of Proctor's new phone that got lost. Oh my God, Proctor, you just are the gift that keeps on giving. You make such great content.
When we've sent out subpoenas, we have not gotten the responses that we should have gotten under the rules and the law, but we've had to put in a lot of extra time and effort and resources to getting these entities to produce documents. The state police still haven't produced documents. I was under the impression they'd been reviewing them for months, just found out from their counsel that they had made little to no progress, and I needed to again threaten a motion to compel in order for them to agree to produce, to do what they have to do. So I agree with you, Your Honor. We shouldn't have to wait that long.
But here we are.
Yes, Your Honor, here we are. Welcome to the upside down world of Norfolk District Attorney's Office / the government / those who don't want the truth to come out as to what really happened. Now, set everything aside, right? Everybody's doing a CYA, right? Which is cover your ass. Somebody has done something and they just don't want all this information to come out. But guess what? It's gonna come out one way or the other. Good luck, Judge. I'll back it up just a smidge.
Them to agree to produce, to do what they have to do. So I agree with you, Your Honor. We shouldn't have to wait that long.
But here we are in February and we're not any further along. I detect a little frustration from you, Attorney Rosenberg, but why don't you utilize the court to maybe relieve that frustration? If you have issues that you need to bring in front of the court as far as a motion to compel, let's get them filed. This case...
Can I just be clear?
It needs to start moving along.
Well, I need to be clear with Your Honor, and I'm hearing you don't want us to confer with these parties and continue to drag out those conversations. The rules, I believe, would require me to do that, and I can't just come into court asking for a motion. But if you'd prefer us to handle it this way when we get non-compliance from a subpoena recipient, I'm happy to do that. I just am sensitive to the requirements of 9C.
Right.
I'm not suggesting you ignore any of the rules. I'm suggesting you avail yourself of the opportunity to use them. And I'm simply suggesting that the length of time that it has taken to resolve issues that shouldn't really be issues appears to me to be excessive. So we have to figure out a
Oh.
way to bring them to a head.
Well, I agree with you, Your Honor. It's just, it's excessive from the recipients of the subpoenas. We're certainly not delaying anything. We've been demanding documents since July, and we've been out there taking discovery and trying to move the case along, which is what we intend to continue to do. So as soon as I have a situation where the recipient of a subpoena is not engaging in good faith conference under 9C, we've been filing motions, and we've had, I believe, 3 or 4 before, Your Honor. Then the parties who have received the subpoenas seem to all of a sudden be more willing to comply.
Magic.
Just before we have hearing in court. And so we are using.
Yes, yes, yes. So they threaten by filing a motion to compel. Sergeant Good, we're talking to you. And then all of a sudden, when they have a hearing, because they have a hearing about every, I don't know, they were supposed to have one in July, got pushed back. So now here we are in February. I don't know when the next one will be, but let's just say every 6 weeks they have a hearing in front of the judge to whine and complain about what is happening and what isn't happening. And as you hear, the judge says, okay, well, then use your powers that be to do a motion to compel. And he's like, well, Your Honor, I want to make sure that I'm doing the right thing. And I don't want to tattle on anybody. And the judge is like, tell me. But it is funny that magically, once that motion to compel or the threat of the motion to compel, like, bammo, you got the information. But just remember, they have to go through these documents. And like Ms. Smith said, and the gentleman from the waterfall said, we'll open them up and it's blank. Remember when Aidan Carney's team got the 400 pages or something from Cosgrove, and there was like 10 pages of stuff and the rest was blank? That's what they do. That's what they do. And the thing is, when they turn it over, they don't look at it. They don't look to see if it's complete. It's a guessing game for them. And that's why they're going to be hiring these companies called, what was it? E-Doc, something another. Anyways, I wrote it down. They're having a third party come in and look through documents, which I find interesting because some of the documents they're not going to be able to look at because they're under a protective order from the Norfolk District Attorney's Office. For example, Proctor's phone. So some of them they're not going to be able to go through this doc service, but whatever. Let's continue. Little me, big them.
Using those tools, and we'll continue to do so.
Anything else?
Anybody?
Not for me, Your Honor.
Anybody? Oh, Mr.
Okay,
Diller
so why
said,
don't we all plan to get together next Thursday at 4 o'clock in the same fashion? And Attorney Diller can report on his success or lack of success in seeking to access the documents. And it'll give you and Attorney Diller a further opportunity to talk about his concerns about categorization or identification of the documents that are produced. And then I'd ask all the parties to submit at this point in time the intended depositions. And I understand that may change, but I want to know who people intend on deposing. Is there anyone that can't make it next Thursday at 4 o'clock? Hearing no response, we'll see everyone next Thursday. Thanks very much.
Your Honor, I have a question though about the request for the intended depositions. Are you looking for that to be a formal written disclosure, or is that something that we could show you in camera so as not to make public all the parties that we intend to depose?
You can share it to me in whatever fashion you want to.
Okay, thank you, Your Honor.
All right? Anyone else have any questions? Okay, thanks very much. We'll see everyone next Thursday.
Thank you. Your
Okay,
Honor.
so for the
Thank
record,
you.
Your Honor.
for the record, this matter is continued to February 12th, 2026 at 4 p.m. for further status, and that hearing will be held via Zoom.
And Attorney Rosenberg, still, because I want to have a clear record here, please, as I indicated earlier, provide the court with a copy of whatever you produced to Attorney Diller.
Okay, it'll come from Mr. Maravellis and Mr. Bell, my co-counsel. The production
Okay.
came from their office.
All right. Thank you.
Your Honor,
Thank you.
Your Honor,
Yes, sir.
with respect to production, who would you like me to coordinate with? Because our office will need to coordinate with somebody from the court with respect to e-discovery. We cannot just send you an email. It's a much more complex process that we've been involved in. We have an e-discovery vendor, and we would need somebody on the court side to have it, to be able to receive it. Otherwise, we can't just, you will not be able to receive it just via email. You'll need some type of technical capabilities to receive the actual documents. So we're happy to coordinate with somebody with the court if there's somebody you'd like to put us in touch with.
You can start with Assistant Clerk Donovan.
Okay.
Okay?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you all.
Okay, so short and sweet, right? That's what it is. And I'm glad that they're doing it via Zoom. Can you just imagine all of these lawyers in court? I mean, beyond what they're billing, right? Let's just say at a minimum, which I know is not true, a minimum of $100 an hour, right? That's 1, 2, 3, 4, 5, 6, 7, 8, maybe 9 or 10 lawyers just that are on this video, right? Who knows who's like behind the scenes, whatever. That's about 10 lawyers an hour. That's $10,000 right there, right? 10. Let me do the math. Make sure I got the right math, right? 10 lawyers times $100 an hour. I mean, that's only $1,000, but I know that that's not true. Let's say a minimum of $500 per hour, and there are 10 of them. That's $5,000. Just at a minimum, right? So, what did we glean from that? Not much, just the same usual fodder. They're not getting the information that they're supposed to. The documents coming in are not formatted correctly. They're having to piecemeal things together. Wah, 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 wah. You know, standard stuff. So now they're going to be going through an e-doc service and going through them and making sure that the court has a record of what's being shared, who has what. And again, the judge is just sort of the babysitter between all of the parties to make sure everybody's got everything and that other people are complying with what is supposed to be given to each party. And that is why civil cases usually take a very long time. I would be very surprised if this got completed, depositions, all the discovery, etc., and that this went to trial by the end of the year. So as you heard, there's no trial date. He's just like, let's talk again next Thursday and see how things are going. That's how it goes. So now a couple of people have mentioned a few things that are happening with this case, and I just wanted to make sure. So yes, that Proctor's deposition is going to be held on April 2026. That the Read team has sent 2 subpoenas to Proctor, the town of Canton, Boston Police Department, Massachusetts State Police, Sean Good, Norfolk District Attorney's Office, etc. So we know that. So there's really not much more that we can glean from that. So we're going to go ahead and end this stream here, but I wanted to give you an update in the Karen Read Civil Saga. That's what I'm calling it. So if you want to hear more about what's going on in the civil cases, make sure you like and subscribe. I know I'm a day behind, but at least you're getting it, right? Anyways, thanks for watching. See you again on the next one. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.